To our Facebook live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Legal, and today we have family law and probate attorney Kimberly Brown to answer the question. Excuse me? To answer the question, sorry, there was something going on there. To answer the question, are there simplified versions of divorce and probate? Hey, Kimberly, how you doing today?
Well, I'm well, thank you. It's a beautiful sunny day here in Oregon and day off. And so everybody seems to be relaxed and ready to chat about family law and probate law for those who have cases that aren't quite as difficult.
I like it. I like it. So let's start with the divorce. You know, in small claims court, if it's a certain amount and you don't have lawyers and you have other kind of want to get it done quick, there's small claims court. So this isn't that, but it kind of inspired me to kind of, go through this with you because there is a simplified version of a divorce, isn't there, in Oregon?
There is. There are very specific conditions that have to be true in your particular case for you to be able to use the it's called a summary dissolution, to use that process in Oregon. The statutory requirement of like somebody has to have lived in Oregon for 6 months. That's kind of across all of the divorce cases. So that's a general rule. But then they had some really specific rules that your divorce case has to be has to have that are true, and if they're not true, then that excludes you from using that process.
So what are the kind of criterias that are unique if you're going to do a simplified divorce?
Yeah. Well, I think the very first thing is that you have to realize that this is meant for what we might call uncontested, not very difficult issues before the court. And so generally, one of the rules, which really doesn't have to do with whether it's contested or not, but one of the things that has to be true is you have to be married less than 10 years. If you've been married more than 10 years, you're not part of this process. You can't use this summary dissolution. You have to go through a more traditional version of it, or more traditional divorce process. You have to have debts that are, I believe, less than $15,000. You have to have an agreement how you're going to divide those debts. There's property that you can't have more than, for some reason my brain is just checking out on the property version of it, but here it is. You can have no more than a net value of $30,000 in property. And unlike in other situations, net value is really about, if you have a house and your house is worth $200,000, but your mortgage is $199,000, then your net value is $1,000. So it's just what's the difference between what you owe and what the property is worth. You're not neither you or your spouse, whether they're joint children or stepchildren, are able to have minor children in order to use this process, nor can you have children that are over the age of 18, under the age of 21, but still in school. You can't use this process if that's true, and neither spouse can be pregnant.
So that takes out the whole concept of having a potential issue that the judge needs to decide, even if they've agreed to custody and any of that kind of stuff.
Right. Well, I think one of the things that this process wants to do is it wants to provide a simpler process for people who don't have a lot of assets, don't have a lot of debts, don't have issues of child support and spousal support. But I suspect that part of the legislative intent in this is that the more assets and the more debts you have, the more I think you need an attorney to kind of explain to you what your rights and responsibilities are in a case like that. And so by keeping the assets and the debts at a lower level, taking out the issue of children and child support or spouse and spousal support, that also excludes you. There's less chance of a mistake being made by somebody doing the process on their own, because part of the summary dissolution goal is to allow people who have these shorter term marriages with simpler facts to them to do it on their own without having to incur the cost of an attorney.
Then how does support matter in a simplified divorce? Can you have a let's say spousal maintenance?
No, none of the supports. Oregon has 3 different types of the support. It has a compensatory, a transitional, and a maintenance category of spousal support. And those are based on various factors as to what you qualify for. But you can't have any of those issues in a simplified divorce. And again, I think that's about making sure that both parties' rights are protected and both parties' responsibilities are protected. And spousal support's a very complicated area of law. Who qualifies for it? How long you're supposed to get it? What's the fair amount? All of that. I've been practicing 25 years, and sometimes I still don't get. Because in Oregon, it's not a hard and fast law that if one person makes X and the other person makes Y, then one person's gonna pay to the other person a certain amount. It's not that. There's so much that goes into how a court determines what's the appropriate amount of spousal support. And it's so easy for power imbalances for people to kind of make an agreement that's just not fair, and it could be not fair because you're paying too much, or not fair because you're not getting enough.
Right.
So, yeah.
So you were mentioning that, basically this is something that is resolved as it's filed. I mean, it's generally a resolved case. How does temporary orders fit into that? Can you ask for temporary orders? I mean, some of the common ones are, what is it? Make no changes, don't dissipate. Are temporaries allowed in a simplified divorce case?
No, and generally, again, I think that has to do with making it a very simple, transparent process. And if you have issues that require things like what we call a temporary status quo order, which means everything stays the same, or a need for temporary spousal support or exclusive use of the marital residence, all that requires more court time if it's disputed. And again, the what qualifies you for these temporary orders is complicated. And so if you have those issues with needing temporary support, disqualified from summary dissolution, needing exclusive use of the marital home, that's got some conflict in it. It doesn't qualify you for a simple, straightforward summary dissolution. You've got a conflict. And so those types of orders are not allowed as they are in the more traditional process of getting a divorce.
Yeah, I know that, and it's unfortunate, but in a lot of divorce cases, there's abuse floating around. And Oregon has the Family Abuse Prevention Act, which oftentimes comes hand in hand with the divorce. But isn't that allowed?
Yeah.
Even because it's not quite a divorce.
Right.
Itself?
Yeah, you're not disqualified from seeking a Family Abuse Prevention Act, which traditionally we just call a restraining order, or an elderly and disabled person's abuse prevention order, which is generally for people. It is for people who are elderly or disabled. It's a little bit of a different restraining order. With a little different requirements than our traditional family restraining orders. Those are allowed. I would say, though, that if we're in that realm, I would be cautious about encouraging anybody to use the summary dissolution, because sometimes in those situations we have that power imbalance. And if you're in a situation where there's a need for a restraining order, that raises a red flag for me. And maybe you're good at doing it. I mean, maybe the person is able to, separate out the issues that required a restraining order and the issues that lead to an elderly or a disabled person's restraining order. But most of the time, there's some power issues and some interaction issues that would make me very cautious to encourage anybody to do a summary dissolution.
Yeah, that makes sense.
Yeah.
Which kind of leads to two final questions on this. One is, this is a filing. What you're talking about, you can't file if these occur. Can a judge look at this thing, even if it's agreed, and say no? Or is it just simply pro forma go through?
I don't know the answer to that question, Steve. I would assume that it's like any divorce, that the judge has the discretion to say no, but I would find it hard that they would have the information in a summary dissolution to determine whether or not it is a fair and equitable or just and proper division of assets and liabilities. I don't think there's enough information in there. So I'm assuming that it probably gets the judge's signature generally, because there's not enough information in that kind of a packet that would make it so that a judge would say, no, I'm not going to sign this one.
That makes sense. And so that's, again, beware. I mean, it's don't do it unless you really, say you're really satisfied with it. And that just kind of leads finally to what if you filed a divorce, or the other party has filed a divorce, or there's, and it's pending. You've got a divorce pending out there. Can you sort of file it in the middle of that and just say the other one goes away, or
no? If you filed it in the more traditional way that we do divorces that are not qualified for the summary dissolution, you can't then decide to file it as an answer or to substitute in. Once you have filed that other proceeding, there just simply cannot be any other divorce, annulment, or separation proceeding pending that are not finalized and file the summary dissolution. You either have to, I assume what you have to do is dismiss the one that's pending, but it might be less expensive for you to just finish the one that's pending, or just decide to, that's your choice. You either dismiss the one that's pending or you continue with the one that's pending, because you can't file the summary dissolution at that point.
Got it. So even though lawyers aren't involved in the actual sort of representation during the case, they can still come to you and ask advice. Yeah,
I think that's really important. If you have any questions about your own rights, whether or not your particular marriage qualifies for a summary dissolution, you might want to talk to an attorney. Whether or not what the agreement you guys are reaching out, hoping to reach is something. If you're feeling a little like queasy about signing on the document, I recommend go see an attorney. Pay for an hour of their time to just see if there's given them the facts and whether or not they have some input as to whether or not you want to sign the document.
That makes sense. That should happen probably on a prenuptial agreement as well.
I have to tell you, I think I just want to give the horror story that I have in my mind, that this is just as one that about buyer beware kind of thing. I had a case come in where the parties did it by themselves. It wasn't a summary dissolution proceeding, but I think it speaks to the same kind of issues, and it had a spousal support claim in it, so it wasn't a summary dissolution, but they did it by themselves, and there was an agreement. The spouse had stayed home for 20 years, no work history, raised all the children, and husband earned in the amount of about $200K, and she agreed to two $100 a month spousal support for 2 years and came to see me after the time where she could have modified the order.
Yeah.
And it was just, so you just got to be so careful that you really know and understand what you're agreeing to, whether it's in a summary dissolution or any other kind of proceeding. And it is possible to do it on your own, but you just got to be careful.
Yep. Well, I like it. I really am kind of not stunned, but it really can be done. But there's a lot of things that have to be, check all the boxes on these things. And if you don't check one of the boxes, you're not going to get it.
Right. And, we still have not figured out a way to do the forms in a plain English kind of way. So a lot of times, understanding the forms is a little difficult. So just be sure that you're clear what this form is asking and what you're putting down. And I think people can do it on their own. Some people have done it very well on their own. But the key component is don't rush it. Yeah.
That makes sense. And that leads to probates. Speaking of arcane language and rules, everybody probably knows, but I'll let you kind of talk about for a second maybe just what probate is in general, and then whether or not there is a simplified version if, again, you qualify for a probate.
Yeah. So let's first talk about what probate is. Okay. So first of all, probate is the mechanism by which somebody's estate, somebody who has died, they leave an estate, and they leave an estate that has property in it that has a title. Okay. And that title needs to be transferred either to a person who's inheriting it or to somebody who's buying that property. And probate is the mechanism by which a clean and clear title is transferred from the decedent, the person who has died, either to their person who they want to inherit it or to somebody who's purchasing it. So it's pretty important to make sure that you use the probate process when appropriate, because you don't want somebody to get a house with, you don't want to be the one to get a house that still has a mortgage on it, or a car that still has financing on it. But it is important that you go through the process. But it can be expensive and take a long time to complete, depending on the size of the assets, the debts, the size of the estate, the debts, where the assets are located in different counties, different states, all that sort of stuff. So it can take quite a bit of time. So Oregon has devised a process which they call a small estate affidavit process. For people who have what are referred to as smaller estates.
I like that. Good term. Well, what does smaller mean? I mean, smaller means many different things to different people.
In Oregon, there's a value to it. You cannot have personal property. And personal property means personal effects. It can be anything from your sofa to your cars, to your jewelry, to your savings accounts, to your investment accounts. All of those kinds of what are called personal property cannot be more than $75,000. So if you have an IRA that's worth $125,000, you can't use the small estate process, the small estate affidavit process. And so you have $75,000 in personal property, and then your real property cannot be more than $200,000. And when we say real property, we're talking about land and buildings. Funny enough, a manufactured home is a personal property issue, not a real property issue. The land that your mobile home may sit on is real property, but the manufactured home itself is personal property. So essentially it's a $275,000 maximum value of the estate of the person who has died. $200,000 for the house and land maximum, $75,000 for personal effects, cars, money, jewelry, collections. And keep in mind, in this particular instance, unlike what we were talking about in small or summary divorce dissolutions, it is not the net value of your properties. It is the fair market value of your property. So if you have a house, like I used an example earlier, if you have a house of 200,000 and a mortgage of 199,000, it's still worth 200,000, so you qualify. But if you have a house, I just had an estate like this, actually, we couldn't get it below $202,000, and it had a small mortgage on it, but we had to file a full probate on it. So, you know, it's 200,000. And you have to wait. The other thing you have to remember is you have to wait 30 days after the person has died before you can file this proceeding. And sometimes it takes that long to get the death certificate because you need that for part of the process of filing.
So how does that process, as you kind of go through it, especially differ from regular, I would say, probate, you know, where most probates hire attorneys?
Yeah.
And so how's that differ?
Well, a smaller state affidavit process is basically, it's an affidavit that you prepare, and it's a sworn statement that's in writing, that the court or a judge accept as evidence of a legal proceeding. So you come in there, I think it's the small state process. There's some forms, mandatory forms that are on the Oregon Judicial Department website of forms, and basically you just say, I am the heir of this estate. I'm a person who would inherit if this person doesn't have a will, but if they do have a will, I'm a beneficiary, a devisee of their estate. And if there's a will, I was nominated to be their personal representative. On TV, we call personal representatives executors. And it's such a popular term that even in Oregon, where we call them personal representatives, sometimes we still use executors interchangeably with personal representatives. But the correct term in Oregon is personal representative. So if the will nominates you as the personal representative, but the estate is worth no more than 275,000 as we categorized it, then you can file the affidavit with the death certificate and with the will. And the affidavit says that we are, that I am duly appointed or nominated, and you submit that, and then you get a certified copy of it. And that's all you need. You can go to the bank, you can change property and all the rest of this affidavit. You prepare, you file, you get a certified copy of it. And that's the document you can take around to the various entities to help you distribute the estate of the person who has died. In the states that are bigger than that, we have to file a petition, and we have to ask the court to approve you as the personal representative based on either your nomination in the will or because you are a qualified person to be the personal representative. And rather than just the court looking at the affidavit, making sure that the affidavit is complete and has the requisite information, the court then goes through all of the processes, all of the paper, all of the petition items that you put in your petition, make sure you have put that all in, and then they actually issue an order appointing you the personal representative. So that takes, right then and there, you're talking a couple of weeks more time to start. You then have to publish for 4 months. If you're going to do the traditional probate, you have to publish and wait 4 months for people to be able to file a claim against the estate in a probate that's the more larger process. Whereas in a smaller estate, you only have to wait, I think it is 60 days to, for creditors to file their claims. And you can go ahead and start, administering it right away, as opposed to, actually, that's not true. I'm sorry, I misspoke, Steve. I'm sorry. You can't distribute the estate from the affidavit, either one of them, for 4 months. But the ability to start doing it is a much, to start processing it is a quicker process, because you don't have to publish in a newspaper under the small estate. So that's the difference, is you don't have to publish in a newspaper.
I mean, do you still do the taxes? Do you still do all that stuff in the small estate?
Yeah.
Or a small estate affidavit?
Yeah.
So you're really still a personal, representative. I mean, you have that duty.
Right. You still have the responsibilities of making sure that you collect and preserve the person who has died's assets. You have to file the final tax returns for the decedent. You have to receive and qualify whether there's valid claims against, some creditor files something against the estate. You have to decide whether it's a valid, you have to take it and look at it and then decide whether it's a valid claim and either accept the debt or disclaim it. If there are valid debts, you're supposed to pay the debts, and you're supposed to sell the assets that are not specifically allocated in the decedent's will. Right. So a lot of times you'll see something like, I divide my personal property between my 2 children. So they have, maybe $500 in the bank and then a household of furniture. So you sell all of the furniture generally. You may ask the 2 children, is there anything you want in particular? Because a lot of people have sentimental attachments to think grandfather's pocket watch, mom's china collection, those kinds of things. And then you sell the rest, and you divide the cash that you receive for those items, rather than give half of the couches to each child. So you can sell those assets. But if the will says, give my pocket watch to my granddaughter, that gets given and not sold. I mean, the person.
Well, here's a question. What happens? I file the affidavit. I get all my stuff back. Everything's hunky-dory. I go to the bank in order to, give them the whatever I have to give them to show that I'm now the person. The bank teller says, well, what about this account that's got $600,000 in it? What do I do then?
You immediately have to convert it to a full probate. And that happens quite a bit. I think a lot of people have a misconception about the full probate being terrible, and there's all this fighting going to happen and everything like that. It's actually very rare that there's a lot of litigation around a probate. Unfortunately, those are the ones that make the news. The probates, I just have to go through this process. And I guess the best example I can give to somebody who's like, oh, I don't want to do a full probate. In just general terms, very generally, if you have a house that has no mortgage on it, and you're doing a transfer of that house, and there's nobody makes a claim against the estate, but nobody looks for any kind of debt, and it transfers to you as the child because you want the house, you don't want to sell it. And then the probate wasn't done correctly, but there's this medical bill that your relative who died, who left you the house, had, and you never filed for notice, you never gave the notice that there was this estate. It is possible that 20 years down the road, I'm being a little bit exaggerating, but think about it, somewhere down the road, it is possible for that medical company to come back and put a lien against the house that you got without any lien against it, because you didn't, the estate was not there was no opportunity for the creditor to make that claim, and they didn't know that the person had died. And so probate, it's that clean title part. That's the most important part about it.
Yep, and that's really important. And between that and these days, a house worth less than $200,000 is pretty darn rare. I guess I would imagine that a lot of sort of the reasoning that went into having this maybe needs to be updated a little bit.
Yeah, and the legislature has updated it in the time that I have been a lawyer, which is 25 years. So it's been updated once since I've been a lawyer. I expect it to be so again, because manufactured homes, which are personal property, it's very rare to even find a manufactured home that is less than $75,000, even used ones. And so, it does need to be updated, just because the cost of living in Oregon, particularly up in the tri-county areas, is just. I don't know that I don't know that I've seen a house for sale for 200,000 or less in a long time.
I can agree with that one. Wow. Well, thank you. We just blew through 30 minutes. So once again, Kimberly, just thanks for sitting down to talk with us today about sort of the simplified versions of divorce and probate that I don't think people know about, or a lot of people ever heard about. And if their particular situation fits, maybe really be a good idea for them. So thank you so much for talking with us today about those. Also, thank you everyone for joining us today. If anyone has further questions on today's topic, you can post it here and we can get you connected with Kimberly or another attorney here. And until next time, stay safe, stay happy,